I'm Mike Steger. I'm a trademark and copyright attorney, and I warned you that this video was coming. In early summer, I recorded a video, which you probably saw and memorized, about how the Supreme Court was going to take up a trademark case involving trademark on T-shirts, Trump Too Small. And that trademark is on shirts that are mocking the former president. The guy selling the shirts filed years ago for trademark registration. It was denied by the trademark office and wound its way through courts. And then last week, the Supreme Court heard oral argument on his quest to force the trademark office to issue a trademark for him. The trademark office had rejected the application because there is a statute, part of the Lanham Act, which governs trademarks, that prohibits you from registering a trademark that includes the name of a particular living individual unless you have that individual's consent. So a name like Trump, where you know who is being mentioned in the trademark, you can't get that without his consent. And when this case was accepted by the Supreme Court, there was some thought that maybe they would look to strike down this provision, because over the past 10 years, they've struck down two other provisions of the Lanham Act. One that prevented the registration of trademarks that could be conceived to be disparaging, and that was a case involving the band Slants. And then they also struck down another provision after that that barred the registration of offensive language. And that was for a trademark for clothing called fucked, F-U-C-T. But during oral argument last week, it appeared that the Supreme Court was going to reject this challenge and not force the trademark office to issue the registration. Part of their reasoning appears to be, from the questions at oral argument, that there is no viewpoint discrimination here. There's just a standard for what you can and can't do, but it's not based on whether something is disparaging or offensive. And also, the Supreme Court appeared to be inclined to defer to Congress because this statute has been on the books for quite a long time. Even with that, there are some couple takeaways for someone who wants to use a trademark that has somebody else's name in it. This guy who's selling the shirts, not being able to get a trademark is not going to prevent him from selling the shirts, and he may actually be able to get exclusive rights in his trademark, not under federal law, but under common law, under state law, where he's actually selling the shirts. So that's what happened last week in the Supreme Court. Should be a decision in the next few months. Feel free to go check out previous videos I've done on these topics, including my other Trump Too Small video, or a recent video I did on the ability to register a trademark in your name. I'm Mike Steger. I'm a trademark and copyright attorney. If you have any questions about your trademark, give me a call.